Want to thank everyone for joining us today, March 26, 2025 at 2:30 p.m. Eastern Time for a really special webinar series that we've held over the last few years that highlight how medical legal partnership can be leveraged actively to address the needs of specific populations or patients with specific types of chronic conditions or issues. So this is our MLP in Action webinar series, part 1, with a special focus on older adult patient population. We are hoping that this webinar will help the field of multi-sector practitioners understand and address the health-related legal needs of older adults and their families. You are joining us on a national webinar hosted by the National Center for Medical Legal Partnership based at the George Washington University. Let's go to the next slide. I am Bethany Hamilton, Director of the National Center for Medical Legal Partnership. I'm only going to be speaking very briefly today for the purpose of opening, moderating, and then closing out today's webinar, ensuring that you know about part 2, as well as some resources for the field. And so I would encourage everyone to please listen in carefully and share your comments and remarks for our subject matter expert who's joining us here today. All right, a few more opening remarks here quickly. Housekeeping, as you know, you're joining us on Zoom webinar. And so you are automatically on mute. But again, encourage you to use the chat or Q&A to send your questions to our subject matter expert who's joining us for the main part of the presentation. If you need any assistance, you can also send us a direct chat message by selecting in the chat host and panelists as opposed to everyone. And if you need to activate the captions on the screen in Zoom, you'll select live transcript or transcript and then show subtitles. This webinar is being recorded. Just give us a few days to conduct a careful review after the video renders and ensure that all of the materials can be promptly shared as need be on our Medical Legal Partnership Resources website. Thank you. Reha, let's go to the next slide. Go to the next slide. Bear with us. Zoom sometimes doesn't do what we want. All right, thanks. All right. So this webinar today is funded by HRSA. The National Center for Medical Legal Partnership receives funding from HRSA to provide training and technical assistance, primarily to a health center audience to understand how to leverage and implement medical legal partnership in your strategies to address the needs of the patient population, primarily supported by health centers. However, the content that we present on our resources, such as webinars or publications, do not necessarily represent the views or an endorsement by HRSA, HHS, or the US government. Just want to emphasize again, what we present today or through other resources do not necessarily represent the official views of the federal government. For more information, you can visit hrsa.gov. Let's go to the next slide. All right, so here are today's learning objectives. We're hoping that our live, as well as folks who view the recording, will be able to, after listening to today's content, be able to name about 2 to 3 health-related legal needs that are faced by older adult populations. We're also hoping that you'll be able to describe the costs and consequences to patients, caregivers, and health systems when those needs aren't addressed. We're also hoping that by the end of today's presentation, you'll be able to articulate at least 4 strategies that medical legal partnership as an approach or your own MLP can use to intervene for those patient populations. And we are hoping to help you identify some free resources to better support your implementation of those strategies. Next slide. So without further ado, I want to turn the mic and presentation platform over to our very special guest and speaker, the national leading expert in MLP for older adult populations, Professor Sarah Hooper, who's an attorney and practitioner at UCSF, UC Law. Her formal title is Professor of Practice and Executive Director of UCF UCSF, excuse me, UC Law, San Francisco Consortium on Law, Science, and Health Policy. This is the institution that runs one of the longest running MLPs for seniors. So I'd encourage folks to look up Sarah Hooper and reach out if you have questions about how to address the health harming legal needs of this population. Also want to emphasize that she's at an academic institution that also conducts really groundbreaking research on that population. So Sarah, we're going to have you bring up the slides so they can continue the presentation. And the NCMLP team, myself, Aubrey, Hannah, and Rahal will be monitoring the chat. So please feel free to engage. Thanks, Sarah.
Great. Hi, everyone. Thanks for inviting me, Bethany. Nice to be with you all today. I am going to share a little bit more about the context I'm coming from and the work that we're doing at our medical legal partnership, and then hope to share a lot of what we have learned in the roughly 15 years that we've been working in this space. So we're based at two academic institutions in San Francisco, California. I'm based at the law school, and we partner with UCSF, and we partner with UCSF across the kind of academic side, the research and teaching side, and the clinical service delivery piece. And UCSF faculty have appointments all over the city. So at the VA, in the safety net, hospitals, and in a variety of clinics and other places. So we really, it's over the years, we've sort of grown to hit a number of sites and to work together in a lot of different ways. So these are some lovely pictures of our trainees and some of our clients and colleagues. As an academically based medical legal partnership, we have a strong emphasis on multidisciplinary workforce training. So we're training law students, we're training med students, we're training residents and fellows across the grad school, social workers, and we try to make that as multidisciplinary an effort as possible. And in part, we are doing this because our current workforce is not quite equipped or ready for the changing demographics and the number of older adults that we have coming through our health system and social service systems and legal system. And they do have some unique needs that I'm going to talk about. And so it's really important to us that we help train not only the current generation, but the future generation of practitioners. Some of our work has included throughout the Bay Area multi-stakeholder training. This was also funded by HRSA, called the GWEP, the Geriatrics Workforce Enhancement Programs. We've partnered with a lot of entities to develop and deliver training and capacity building. And in California, for the last several years, we had a partnership that was statewide, that was a medical legal learning network focused on dementia care. And you can see there were about 16 organizations across the state that were focused on thinking about how we can improve training and service delivery for older adults with dementia. As Bethany said, some of our work also involves research. So our medical legal partnership has been really interested in advancing theory and driven practice change across settings of care. So some of the things that we've been doing has been helping to design new care models. So our MLP actually helped to develop the workflows for patient navigators in this clinical trial for patients and caregivers with dementia. And the idea is, how can medical legal partnerships not only help inform care delivery on the ground right now, but what are the kind of care models that we can think about helping to develop and sustain and scale that can help people not, beyond our immediate community. So we're really interested in that. And we've developed some tools that I will tell you more about. These tools are actually 50 state multi-jurisdictional tools. And I'll say more about them in a little bit. And then, of course, our medical legal partnership engages in individual patient client advocacy, as do, I'm sure, many of you. Our referring providers and partners are at UCSF Health, San Francisco VA, and the San Francisco Health Network, some of the clinics and the hospital that sees a lot of high need older adults. So our patient-client population that we see in medical legal partnership is highly socially isolated. So you can see here 67% of them are socially isolated, 60% of them are at risk of institutionalization because of disabling conditions, health conditions, and lack of social supports in the community. And the majority of them are at or below 200 of the federal poverty line. We're in San Francisco, housing costs are very high, so we do see people up to 400 and sometimes beyond percent of the poverty level because they're living in poverty in San Francisco. So our MLP model is highly mobile. Our students, our attorneys actually often go to patient client homes. And that is a big way that we reach them. They're identified through their healthcare provider, but we are not necessarily always seeing them in clinic or the hospital or long-term care. A lot of visits are done in patient client homes, though we do see people across different settings of care. Okay, so that gives you a little bit of a sense of who I am and our group and sort of what we've been up to and where we're coming from on some of this. And so I wanted to share a little bit about what are health-related legal needs of older adults. And the short answer to that is that they are the same as everyone else, right? Housing, income, but they present differently. And there is a cluster of health-related legal needs that are predictable, and that we see a lot. And so I want to share our experience of what those needs are, as along with some of the data that I think suggests that our experience is not unique. So I actually thought a patient case would be helpful, and this is some of these facts have been changed for confidentiality purposes, but I will say that this is not an atypical situation that we see. So Mrs. Chase is an 82-year-old woman. She has multiple hospitalizations and ED visits in the last 6 months, primarily for UTI and dehydration. Her daughter Miriam is her primary caregiver, and they live in in a low income neighborhood. And Miriam has a job that pays her on an hourly basis. And she is kind of the main person responsible for caring for her mother. And she reports significant caregiver burden. At one of these visits, they were seen, and the care team thought it would be helpful to do some advanced care planning. So they noted in the chart that Miriam was her primary caregiver. I think they put it under emergency contact and talked about her end of life wishes. And in California, end of life wishes can be documented in a post. And most states have some variation of a post, but it's an order that mostly talks about treatment preferences at the end of life. And this is pretty usual advanced care planning for someone of her age. And the mechanisms, right, a note in the chart and a post, are considered usual or standard care in a lot of places. Unfortunately, a few months later, Mrs. Chase was found by police in her bathrobe after wandering. Her daughter had left for like 30 minutes to get some milk from a neighbor and came back, and her mother was gone. She just kind of forgot where she lived and was wandering and was really upset. So the police took her to the hospital. And for the first time in the hospital, she received a diagnosis of dementia. And so the team worked really hard to get her. They thought, she needs more help. It's clear that Miriam is having a hard time meeting her care needs. And so the discharge planning team recommended that she go to an assisted living facility. So not a SNF, not a skilled nursing facility. She didn't have that level of medical need, but she did need more help in the home. And so they found an assisted living that they thought would be appropriate for Mrs. Chase. But in the process of discharge, the assisted living facility started pushing back and saying they needed a financially responsible person to sign Mrs. Chase in, and was concerned about a whole bunch of things happened in this transition of care. And one of them was that Miriam doesn't have a durable power of attorney that says she can access and manage her mother's finances. And she also didn't have any legal recognition as a rep payee to manage or make those decisions either. And so the assisted living facility was concerned about taking her without those formal authorities. So the discharge team advised Miriam that she needed to file for probate conservatorship because they felt her mother no longer had the ability to name Miriam on her own. And so Miriam was going to have to go through this court process to get a court to appoint her to be that decision maker. So in California, we call it conservatorship, all like most forms. So conservatorship of the person, conservatorship for medical decisions, conservatorship for the estate, we use the same term. Other states, you may be in a state that calls it guardianship and conservatorship, depending on the form, it may be another thing. But it's all the basic principle that if someone has lost capacity and isn't able to meet their own care needs, someone may need to go get the authority to make decisions for them, and they would typically have to go to a court to do that. Miriam is not particularly trustful of legal systems. She doesn't have the money to go hire a lawyer. She doesn't understand why she can't just make decisions for her mom. So she kind of balks at this process. And she's also already really overwhelmed. So she becomes more difficult to contact. And the discharge team starts to think she doesn't really have her mom's best interests at heart. And they consider making a referral for suspected elder neglect and are thinking about referring this case to the public guardian's office. And as all of this is unfolding, Mrs. Chase is in the hospital and hasn't been discharged and is experiencing an extended length of stay in the hospital. And the team is not sure they can discharge her at all before she has a conservatorship in place. And a conservatorship could take 6 months to a year if it is successful to get put in place. Okay, so again, I'll share some statistics about why this is not actually an unusual case. This is something we hear from hospital discharge teams up and down the state and around the country. But before we get to sort of the statistics around this, I want to unpack what's going on here and so when I look at this case, there's the near-term situation that we need to work through, right? But in so many of these cases, what I think is, I really wish we had met them a year ago, right? To help them avoid this situation and help the healthcare team avoid this situation. So I'll unpack for you kind of the unmet medical, legal, and other related needs that got us here, right? And I'll hopefully leave you with some hopeful ideas for how we can, and concrete ideas for how we can fix this. So there's 4 buckets. I'm going to talk through each one. The first one is, of course, that her cognitive decline went undetected and her dementia went undiagnosed. And it's important to understand, and many actually don't understand this, that dementia is not a natural feature of aging. It is a disease, and it is a leading cause of disability among older adults. It is a progressive illness that can lead to a decline in capacity, and I mean mental capacity, but I mean other functional abilities. And that decline can have implications for that person's care, including who gets to make decisions about their care, right? And also their maybe legal rights to access to certain services, which I'll talk about. By 2060, we are projecting, well, not we, but these authors here that I have cited below have projected 1 million cases annually. And they've also noted some differences in lifetime risk for dementia with a higher lifetime risk in women and Black adults for acquiring dementia. We know from research that has been done on dementia that older Black and Hispanic Americans are more likely to acquire Alzheimer's and other dementias, to not receive diagnoses for those conditions, and to report some specific kinds of legal issues as they seek care for a person with dementia or for themselves. So lots of barriers. And in FQHCs, a study in 2024 of 5 federally qualified health centers in Indiana found that 62% of the older adults assessed had previously undiagnosed mild cognitive impairment, and 12% of them had previously undiagnosed dementia. And Black patients were 2 times more likely to have mild cognitive impairment or dementia than white patients. And so you may be asking, and many of you are maybe familiar enough with dementia, you know that we currently have no clear cure, although there are some treatments that are coming available. Why should we detect this early if there are no clear medical interventions or we're not sure about their benefit? And what I would say from a medical legal partnership perspective is that if we detect it early, that gives us time to plan, right? It gives patients and families and the care team time to put plans in place to hopefully avoid the situation that we saw with Mrs. Chase. It is also not entirely true that there are no medical interventions. We know that there are often underlying medical things relating to capacity that we can address to optimize a person's ability to participate in their own decision making. That may be something we look at as an alternative to pursuing a conservatorship. So, for instance, a medication review can help us identify if someone's cognitive impairment is being made worse by certain medications that they're on, right? And we know that in the US, older adults tend to be highly medicated, multiple medications that can have effects to their decision-making ability. So screening is the first piece of this because with a progressive neurodegenerative illness, we know that there may be a point, and we can predict that there may be a point when this person can no longer make decisions and is going to need a lot of help. And if we miss that window, we are really setting ourselves up for many more difficult things. So the other piece I want to talk about is the ACP that happened with Mrs. Chase. When I say ACP, I mean advanced care planning. And again, what is sort of standard or usual care is that we're used to defaults in medical decision making. We're very comfortable in most states with the idea that if someone hasn't formally appointed someone to make decisions, a family member or someone else can be turned to make decisions for them. And we often just document the person in a medical record. And like I said, there's been efforts to try to increase the use of PULSed in documenting treatment preferences. But the thing that doesn't work here for older adults who have disabilities, including dementia, and who need more care, is that they transition across many settings of care. And so the note in the medical record does not necessarily go with them, right, to the assisted living facility or to other places. And so it would be better for caregivers and for patients if we actually filled out the durable power of attorney for healthcare to make it very clear who the person wants to make decisions for them and to help that caregiver provide that care across the many settings of care that the person will want. We also tend to think of advanced care planning as about decisions about death. But right now, Mrs. Chase needs support to live, right? She needs support to live in her community more safely. And so it's a transitions of care, it's a housing decision, it's a personal care decision. And that is not something that is well captured in a tool like Pulsed, right? Those are decisions that are in other documents. Personal care decisions can be stated in a healthcare directive, but often practically someone needs the ability to manage her resources, right? Her daughter needs the ability to manage her money and her public benefits and her property in order to get her the care she needs. And in most states, healthcare decision makers do not have financial decision making authority. And so she needs separate tools to give her daughter that authority. Um, I will say more about that in a little bit. So hopefully I've shared a little bit about why kind of current practice isn't quite enough to manage the complexity during the lifetime of an older person to meet their care needs. The other thing, and this is related to the financial decision-making piece, is that a lot of care for older adults is not necessarily medical care, but it is care that supports activities of daily living and instrumental activities of daily living, also known as help with community living or help with a disability, right? Half of adults over the age of 65 will need help with activities of daily living, and 1 in 7 will need help for 5 or more years. And that statistic is including, is sort of an average across all people, all older people with all conditions. I think if you drill down to the dementia population, those needs can get higher. So someone with dementia may live 10 to 15 years, again, live with incapacity or live with a need for more functional support. And the long term, the kind of care that they need is extremely expensive, as you can see from this Kaiser Family Foundation graph here. And they're generally not covered by Medicare. The Medicaid program across the states is the #1 payer of long-term care supports and services in this country. So you can see, for instance, that assisted living, the typical cost for a 1 bedroom is about $64,000 a year. And so for even people in the middle class, right, this isn't even necessarily just a poverty problem, though it is, even people in the middle class have a hard time affording the out-of-pocket cost of long-term care, or at least for very long, right? So some of these services are basically like sending a kid to college for 10 years, right? And so many families simply cannot afford that. And so the payer historically for these services has been the Medicaid program. Many older adults mistakenly believe that Medicare will pay for these services. And in recent years, there have been some attempts to expand the types of services that the Medicare program will cover into things like respite care and other supports and services like these. But it's still relatively new, and it sort of depends on the Medicare Advantage plan that you're in and other sort of demonstration programs. So it is still the case that Medicaid is a very important program for meeting these needs. And working with the county Medicaid office often requires authority of a younger person to do that. One thing I wanted to just make really clear. So I said earlier, when in the healthcare system, we're really familiar with defaults for healthcare decision making. We do not have those same defaults for financial decision making or management of public benefits, right? So if your daughter or son goes to your bank and says, my mom needs a ton of care very suddenly, we didn't anticipate it. Can I have access to her bank accounts to pay her bills? They're going to tell you to go take a hike. We just do not have those same defaults. And for good reason, right? We want to make sure that an older adult has legally named someone to do those things for them, and that person is trustworthy, and we want to try to protect against exploitation. So we just do not have the defaults for the array of other services that people need that I think many in the healthcare system assume are possible. So these are real barriers that family caregivers can run into. We have these needs. We sort of have these predictable legal needs for older adults who we can predict are going to need more help and may lose capacity at some point to make their own decisions. A majority of states now recognize supported decision-making agreements as one form, one legally recognized form in which a person can name someone else to support them in making decisions. That person cannot make decisions for the patient. That is a limitation of an SDM agreement. You still, in most states, to my knowledge, need a durable power of attorney for healthcare and for finances for someone to be able to make decisions for another person. And these documents have to be executed when the person still has capacity. We see lots of caregivers and healthcare teams who think, oh, let's just have the caregiver fill out a durable power of attorney. And that is a huge no-no. That's a no. It will be an invalid document. And we want to protect everyone because it could also be seen as a crime, right? And it could also be seen by others as an attempt at elder exploitation. So we want to make sure that we're doing this early enough and in circumstances that everyone feels good about the document that we're completing. A Social Security representative payee is someone that a person can name. It's called advanced designation to manage their Social Security, any benefits that come out of the Social Security Administration. And usually you need both, right? So Social Security is a federal program, which is why they don't automatically recognize legal documents that are a product of state law. So often your durable power of attorney is helpful, but not enough. You also need to advance designate a Social Security representative payee. If someone is a veteran, again, the Veterans Administration is a federal entity, so they don't necessarily rely or lean on durable powers of attorney. They have their own decision-making mechanism, and it's called a VA fiduciary. So someone who's a veteran, who is getting certain kinds of benefits, who has lost capacity, would need to get a VA fiduciary. And to be clear, someone like Miriam, so like let's say her mother is a veteran, and let's say she receives Social Security benefits, and pretty much everyone needs POAs. Miriam can wear all of these hats, and she may need to wear all of these hats. And some families divvy up these responsibilities among different people. So that's the decision-making piece. And then the other kind of just practical piece, again, because older adults have a number of federal and other programs that they rely on for income, housing, long-term care, and other meeting basic needs. Those programs can have complex requirements and they don't always knit well together. And so having some assessment and planning and advocacy to prepare them for that can be extremely helpful. Unfortunately, so we can kind of predict that these are needs that are coming down the pike for a lot of older adults, but unfortunately, a lot of older adults with the highest amount, the most complex kind of medical needs for which we can predict they will need legal help are not getting access to legal help. So in the 2025 LSC survey, they found that 70% of low-income seniors had a civil legal need in 2021, and 31% of those had multiple civil legal needs. And for those needs, 91% received inadequate or no legal help. So a big function of our MLP, as with many MLP, is can we get to the older adults who most need us at the time that it would be appropriate and important to intervene? And can the healthcare system help us get there at the right time in the right place? And that, I think, is what's really critical about the partnership. Okay, so we've talked through why it's important to detect cognitive decline early. We've talked about what are the missing kind of legal components of the plan. I want to also talk a little bit about the caregiver needs of it all, because in this scenario, we are relying heavily on Miriam to navigate and access care, and the care team was getting sort of frustrated with her when they didn't think that she was working in her mother's best interest. So a little bit of context here for those of you. So 1 in 5 Americans provide unpaid family care, and the vast majority of them are working while they are providing that care. 28% of them are sandwich caregivers, which means they're caring for young children and older people at the same time. And we know that Black and American Indian Alaska Native children are more likely to live in grand families. So grand families are where the grandparent is providing care as the sole adult providing care for the child. So lots of caregiving responsibilities, both for and by older adults. But most of us never receive training for that role, right? And critically, we don't receive training about our legal responsibilities in that role. So while we are encouraging patients to engage in planning while they have the capacity to do that, we also need to be educating caregivers and preparing caregivers for that role. And so, and most of the time, their needs are consistent. I'll talk about some ethical and other issues in a minute, but it's important for Miriam that she have legal recognition of her role, and that she understands her legal responsibilities as a decision maker, both for her own protection and so that she can be a better advocate for Miriam. She needs help in understanding how to manage Mrs. Chase's money and public benefits in a way that will be helpful to them both, right? It is often in Miriam's interest to get help providing care, right? As well as her mother's. So some legal issues that can come up for caregivers are paid family leave or medical leave protections in the workplace for caregivers. So that's a really important piece of caregiver education. In many states, the Medicaid in-home supportive services programs will permit family members to be paid to provide care for a family member. And often family members just may not be aware, right? So we don't know often what Miriam understood about her ability to take time off to care for her mother, what she knew about respite care, what she knew about IHSS and similar programs. But identifying these resources and wrapping them around the two of them can be really helpful. And then, of course, addressing her own legal and other health-related needs can help reduce her stress and burden. A challenge, as many of you in this space likely know, is that unfortunately it is also true that older adults are subject to elder abuse and neglect. And the vast majority of cases of elder abuse and neglect are perpetrated by someone who is known to the older adult. And so family members are perpetrators in 47% of cases, and medical caregivers who are not family in about 13% of cases. Nearly half of people with dementia are thought to have experienced some form of elder abuse or neglect. So how do we balance this need to include and educate and advocate for caregivers while also understanding the risks here? We do it very carefully is the answer, by hewing closely to professional ethics rules, and by being very careful about the ways in which we help them with advanced planning across all of these needs. And if we're doing it correctly, medical legal partnerships are not just document mills. We're doing a lot of work to get to know the older adult and the people in their life and their goals and their needs, and helping to assess risk that the documents might be exploited. So it's not a separate thing that we're doing. It is a thread that is woven throughout all of our work. We're sort of constantly thinking about the possibility of that. And finally, missed social care connections. So it's important to understand the ways in which services for older adults are a little bit different than services for other populations. So the Older Americans Act for decades now has provided a federal framework that is then implemented at the state and local level for supports and services that are required under the statute that was passed by Congress to be provided for free to older adults age 60 and over in their communities. And you can see how that flows down from the Administration on Aging to the states and tribal organizations to the local area agencies on aging and local service providers. And you can see here that a lot of the needs that are provided for older adults have been there in the community to varying degrees, and we can talk about the details of that, but at least in theory, these are entitlements under these programs, and they're there, but they have not historically been well connected to the healthcare system where folks like Miriam and Mrs. Chase would need to access them. And it's also important to understand that legal services have always been part of this framework. It's not specifically named here, but under Title 3B of the Older Americans Act, AAAs and states must provide legal services without means testing to people age 60 and over for free. And that is in every state. And different AAAs have different contracts with different provider organizations. But it's important to understand that there are different funding streams. So Legal Services Corporation provides funding for agencies that serve older adults. But it's important to understand that there is also this framework for care of older adults that exists in the communities that we can connect them to. And unlike LSC funding, there is no means testing for services for older adults. Okay, so to summarize what we've talked about, if we identify cognitive decline early, this allows us to intervene at the point when an older adult has the most ability to make capacity for their care needs, not necessarily just at the end of life, though that's important too, but for the many years when they may need more and more care and help from other people. It gives them and their families time to address a host of needs, like where they will live and receive care and how they will marshal their public benefits and money to pay for that. And we can do this across settings of care, but of course, primary care would be ideal. And so you may be saying, gosh, Sarah, this seems like a lot. But remember where we met, where we left Mrs. Chase and Miriam. When we don't do these things, the needs don't just go away. They just get more expensive and difficult to address, and they pop up in other areas that have real costs to counties and states and hospitals and others. And a lot of those consequences are extended length of stay, conservatorship, elder neglect, and in the case of Mrs. Chase, it was police and first responders that picked her up. So to put some data around this, we actually have fairly poor data in the conservatorship space. It's sort of notoriously bad. But Jennifer Moy in 2023 did a study and found that conservatorship is a significant contributor to extended length of hospital stay nationally. And it's bad for patients because extended length of stay does risk poor health outcomes for those patients. So for any attorneys on the line who think that being in the hospital is a safer place, that's not necessarily the case. There's just different risks there, particularly for older adults and particularly for those with dementia. In a statewide all hospital study in Massachusetts, these researchers in 22 found that conservatorship accounted for about $18 to $25 million in bed stays annually. And we and some colleagues at Duke have estimated that the per hospital annual cost of preventable conservatorship is somewhere between 100K and $1.2 million annually. Um, so, so when we don't do anything, again, the costs just appear elsewhere. We should also think about, and so we do have a little bit of data that Jennifer Moy has put together. And when I look at this data, she did a Veterans Health Administration chart review study in Massachusetts, and she found that conservatorship was sought for, the majority of those conservatorships were sought for people with dementia. And a majority of them had a family member already. Um, and 43% had to go to a professional. And this interests me because I often hear of conservatorship as a no caregiver problem, or for someone with like acute schizophrenia or something like that. But actually, what this data tells me is there's a lot of low-hanging fruit. There's a lot of folks for whom we can see these problems coming, and we could be intervening earlier to help drive down the numbers of avoidable conservatorships. It's important to also name who tends to be conserved. Britney Spears, her case garnered a lot of attention a couple of years ago, but most conservatees do not look like Britney Spears. You can see from two studies here in Florida and New York City that conservatees tend to be disproportionately older, low income, and disabled women of color. It's important also to understand the impacts of conservatorship on patients and families. So if you think about Miriam, she didn't know, right? She just didn't know that all of this planning, the importance of all of this planning. And so she is now faced with a lengthy and expensive court process that she is terrified of and frankly doesn't have a lot of time for in her life. And so it's really burdensome on families. It represents a loss of civil rights in patients. And I think that we can't underscore how significant that is. We all want to have a voice in our care. Um, and it can hit some of us differently if we are not allowed to have a voice in our care, if we have not previously felt that we had a voice in our care through our whole life, right? It's also important to know that we have almost no data on outcomes of conservatorship in terms of whether it actually helps improve health and well-being of patients and their family members. Um, and so I find that in working with a lot of teams, we tend to overestimate the benefits of conservatorship and underestimate its potential harms to families. We did a lot of this work on conservatorship at discharge at the San Francisco VA with a team called the TRACK team. And you can see our publication here. We worked with the care team there to optimize and identify less restrictive alternatives to conservatorship in patients and helped put together frameworks for the care teams there. And what we found is that the rights-focused approach was consistent with cost containment goals at the VA. Okay, so I've talked about a lot of different potential interventions. I want to share some resources with you. So we have, as part of our work, been trying, as I mentioned, been trying to develop training and tools and resources that we can share with others. So as part of the statewide project, we developed free training that is CEU bearing for healthcare teams in how to conduct capacity assessments and to do early cognitive screening and follow on in dementia care. And we developed a bunch of materials about the health related legal needs that care teams can be aware of to try to reassure you and provide some resources, that there are resources out there. If you do this screening with patients, you won't just be screening and then leaving them there. One of the tools that we have developed and are going to start offering in July with the help of the AARP Foundation is a tool that helps patients and caregivers learn about legal and financial aspects of care planning. This is a 50-state tool that will also be available in Puerto Rico in English and Spanish. And we are developing a healthcare team facing version of this with some quick screens and some resources for if we are identifying these needs, kind of what do we do next? So that's what those tools are going to be for. This is a national grant, and so we would love to work with your MLP or your site, even if you don't have an MLP yet, but you're trying to start one, to help you think about how to integrate these tools and how they fit with kind of on-ground service delivery. We also have training for healthcare teams in how to integrate caregivers as partners in the care team. And it does include some of the legal components of that that I've been talking about. And that is available, again, a free training, CME, CEU bearing, and we'll be doing live trainings around the country. So we have some tools. And then, of course, your local legal partner, your MLP partner, can help identify who is at high risk of loss of capacity, institutionalization, at risk of conservatorship, and can be the resource to actually help put those plans in place. So I come to this with a high degree of optimism. I think it's absolutely doable to address some of these needs together, and the medical legal partnership model is uniquely well suited to help at the individual level and at the systems level really serve our elders better and be prepared to continue serving them well into the future. So here's my contact information. If you're interested in any of the training or tools, resources that I've talked about, please do reach out. We would love to work with you. And with the remaining time, I think we're going to ask for questions. I'll stop share.
Thanks so much, Sarah. We do have some questions that have come in, so I just want to encourage people to use the chat while the NCMLP team continue, or the Q&A to submit any questions or even comments. So a question came in, Sarah, and it's from Tamara Groman. Do you know of any MLPs that actually formally partner, not just do a referral network, but actually partner with social services agencies to provide care, such as care management, Meals on Wheels, social programming? Perhaps those are some of partnerships that work at the AAA programs. Do you know of any that we might be able to highlight and can point Tamara and others to that have that formal partnership in place with social service agencies?
That's a great question. I'm not sure how formal you're looking for, if there's like an MOU. Our MLP certainly informally partners with others in the aging network to provide kind of holistic services to older adults. At the moment, we don't have any. Well, one thing I will say is that because one of our contracts comes through the AAA, we kind of know everyone else, all the other grantees, and they help to sort of support that networking. I'm not aware of anyone with like a formal MOU with specific agencies, but happy to help brainstorm that a little bit more.
Yeah, when the question came in, I appreciate both the question and your response there. I started to think about how flexible the medical legal partnership approach is, and that even if the formality really is between the direct service provider for healthcare and legal services, it doesn't mean that a referral network that's created to further support that MLP with another social services agency isn't effective and helpful. And so I would, just take a minute to just, examine. Same thing. I can't actually identify off the top of my head a specific example that directly responds to that question, which again, I appreciate it coming in. But MLP as an approach and intervention is flexible. And so you may not need for that additional partner a formal MOU agreements in place for that referral network to be just as effective and supportive for the MLP's work for older adults or other types of patient populations. All right, let's see what else came in. Let me pose a different question. Sarah, I think a lot of folks who might be at FQHC, which focus on lower income, vulnerable patient populations, pretty familiar with like the Medicaid population. Would you suggest any ways that they might be able to look at their patient population either through the EHR data set or work with any partners in the community, such as AAA, to better conduct some targeted outreach to the population so that they can learn more about what their legal needs might be and begin to develop the partnerships to address those needs? So places to start basically is what I am posing as a question for you.
Yeah, great question. So the data question, the data from the FQHC study suggests that if you have folks over than the age of 65, there's a good chance they have mild cognitive impairment. There's a lot of them. So you could set up a program to offer all of your patients and even 65 is maybe too late. People qualify for Older Americans Act services at age 60 plus. And some states' programs have other money to even be more generous than that. But 60 plus would be a good point to start assuming that your patients have legal needs that are simply unmet. And I would argue they don't even need screening. The screening tool we're developing in Clarity essentially screens to see what amount of legal planning they have done yet, and then creates a short list of what they have left to do. So that would be one way that you could work with your MLP to say, okay, we have X number of older adults who are 60 plus, who, whether or not we've actually screened them or diagnosed them with dementia, it's likely that they are going to have care needs. And can we support them with some planning for life, for their lifetime, not even necessarily for their death?
That's great. It's a really great suggestion that even makes me think about another great place to start after taking a look at that data is even if there are folks who are on here who aren't currently carrying out or implementing an MLP or ready to actually start one, maybe offering legal clinics and legal education in that regard is a great place to begin the MLP journey to better support the older adult patient population, as well as their family members who might be coming in, and they're the ones who are the direct recipients of the information and taking it back home or in their community. So a lot of opportunities to support the population and address their holistic care needs. All right. I think that's all in terms of questions, but want to sincerely thank you, Sarah, for helping us kick off the MLP in Action webinar series. On the screen, folks will see just a quick highlight of some resources that have been developed thanks to also our other grantee friends, such as NCECE, along with Sarah Hooper. They are a few years old, but they're still relevant and helpful. So you'll see an issue brief on socially vulnerable older adults and how MLP can be leveraged to support older adult health and well-being. You'll also see another link to several resources that have been created to support or help you better understand how to support socially vulnerable older adults and leverage MLP. And then finally, you'll see the Health Center MLP Toolkit that'll help folks in the planning, implementation, and actual practice of MLP for all populations. So we'd encourage folks, once you receive the slide deck, to take a look at these resources, download them, share them. In addition to the other resources that Sarah shared, some really exciting work is being done through what she's doing at UCSF, along with other partners. All right, let's go to the next slide, because this was part one of a webinar series. Also, just want to highlight, sorry, before we move on, our friends at Justice in Aging are also continuing to offer some really helpful, timely, and relevant resources. As you might be wondering, what can you do to support older adults who might be dual eligibles? Medicaid, where you continue to hear about potential changes that may impact the population. And if they are dual eligibles, also Medicare or other types of supportive resources. I strongly encourage everyone to go to the Justice in Aging website. They have a resource library that includes written resources as well as webinar events, and the archives are being posted regularly. And you can also sign up for their email so you can receive their newsletter and know when they release new resources. All right, so now on the next slide, you'll see part two of this MLP in Action webinar series. So Professor Sarah Hooper helped us understand at the national level, big picture, what do older adults face in terms of health harming legal needs? And then what can we begin to do to address those needs that might be legal in nature, and what can MLP do? In part two, join us on April 24th, where we'll hear from the Pennsylvania Health Law Project about at least one example, Medicare in particular, and how healthcare organizations can really do a deep dive to not just understand Medicare, but help older adults actually ensure that they have access to Medicare benefits, and then other programs that are in place to support the older adult population. So don't worry that it'll be Pennsylvania or any particular state. We're just leaning heavily on our Pennsylvania Health Law Project friends to help us do that deep dive, especially for healthcare teams on Medicare, helping older adults access it, gain its benefits, and then also other programs to support them and their families. All right, so you can use the QR code to register, and also in the MLP update, we'll continue to promote that, as well as on Blue Sky, so that you can join us on Blue Sky. You'll see us continue to promote the part two of our MLP in Action webinar series there. All right, finally, you'll see an additional list of upcoming events. So this Friday, we'll continue with the MLP fundamentals, group coaching sessions, where we're diving deep into information sharing and privacy essentials. Also pertinent to services, quality services being provided to older adult populations. And then we'll go into starting next week, a brand new learning collaborative on getting the funding that you need. So we'll be joined by some special guests from the MLP world, as well as foundation, that'll help everyone work collaboratively to build effective relationships and pitch decks. And then we'll continue again for part two of this webinar series on April 24th. And then on April 29th, we'll actually be joined by Legal Aid of North Carolina, their MLP and legal leads, on learning about how legal aid can be leveraged in disaster response and recovery efforts. So they'll talk about the collaborative approach that they took to supporting communities that were devastated by Hurricane Helene. You can use the QR code off to the top right of your screen to join us on that webinar. And I think there's just one final thank you. I want to sincerely thank Professor Sarah Hooper for stepping away from her day-to-day work at the university with law students, with research teams and others that are actually delivering care and services, and for presenting educational content on today's webinar, as well as the folks who joined us today in the audience. We know you are also stepping away from your work to be able to receive this content. And let me ask everyone to please fill out our SurveyMonkey evaluation to let us know how helpful this content was, but also